Welcome to Unit 4 of Week 6. In this unit, we'll be talking about the demise of Chevron. So before Chevron was overruled by the Supreme Court in 2024, it was eroded. And one of the ways that it was eroded was the rise of the so-called major questions doctrine. And this doctrine provides that agency rules that may have broad economic and political significance must be authorized by a clear statement from Congress. And we actually saw the court apply this reasoning in King v. Burwell. SCOTUS later endorsed this major questions doctrine again in a major case known as West Virginia v. EPA, a 2022 decision, which struck down the EPA's Clean Power Plan for reducing carbon emissions from power plants. So since that decision in particular, regulated parties have been regularly relying on this major questions doctrine to avoid application of Chevron. Then on June 28th, 2024, the Supreme Court explicitly overruled Chevron after granting cert in two cases, Loper-Bright and Relentless. Importantly, these decisions overruling Chevron only apply going forward, so they're not going to be given retroactive effect for cases that have been decided over the past 40 years. The court has said that those should remain settled judgments. We have over 18,000 cases citing Chevron. But going forward, questions of statutory interpretation are going to be addressed very differently by courts. The reasoning for overruling Chevron that Justice Roberts gave in the majority opinion is that Chevron conflicts with the Administrative Procedure Act, or APA's directive, that courts should decide all relevant questions of law. And the majority interpreted that to mean that courts must apply their own judgment and not defer to agencies' judgments about what the law means. The court also noted that many exceptions had been carved out of the Chevron doctrine already, and that the Supreme Court itself had not relied on Chevron since 2016. So Loper-Bright leaves the door open still for Skidmore deference, so courts can still respect agency decisions that are persuasive. However, the courts will no longer defer to any reasonable agency interpretation of an ambiguous statute, as was previously required under Chevron. The dissent in this case highlighted the fact that agencies do have technical and scientific expertise that courts generally lack, which the dissent thought puts them in a better place to decide on a reasonable interpretation of a statute, or to decide between reasonable interpretations which one should prevail. The dissent was also worried about the jolt to the legal system overruling Chevron would create, particularly if parties started coming up with special justifications for asking the court to review old settled issues. Additionally, the dissent noted that Chevron has supported all kinds of regulatory efforts. So in the environmental arena, keeping air and water clean, keeping food and drugs safe, and financial markets honest. The dissent was also doubtful that the Skidmore test that was still left for courts to apply will actually add clarity. The dissent pointed out that, people still disagree, judges still disagree about what giving respect means and when it's required. So as we look towards the future of Loper-Bright, it's not really clear yet what impact it will have, and it may depend significantly on the substantive area of law. So in environmental regulation, it may become more difficult for the EPA to take actions to protect the public and the environment. In immigration, on the other hand, many advocates for immigrants are really happy to see Chevron gone because it often resulted in deference to agency decisions that were adverse to immigrants or involved unpersuasive reasoning regarding statutory interpretation. In general, I think we can agree that agencies will feel more pressure to justify their interpretations of statutes. Another concern is that it may significantly increase the workload of the federal judiciary because instead of just reviewing whether an agency decision was reasonable, they now have to construe statutes themselves.